Please be seated. The sitting is open. The court meets this afternoon to hear the remainder of the second round of oral argument of Myanmar. I shall now give the floor to Professor Tamo. You have the floor, sir.
Mr. President, Madam Vice President, distinguished members of the court. It is my task in this final speech of these hearings to respond to the Gambia's argument on burden and standard of proof, and to provide answers to the related questions by Judges Charlesworth and Pillai, Gomez-Robledo and Hammoud. Let me start with the question of the burden of proof. The Gambia now agrees that it has the burden of proving the facts to establish breaches of the Genocide Convention by Myanmar. It also agrees that it must prove one or more of the acts set out in Article 2A to D of the Convention, that these acts were attributable to Myanmar, and more importantly, that Myanmar had the intent to destroy the Bengali Muslim group in whole or in part as such. Mr. President, members of the court, let me now turn to the standard of proof. The standard of proof determines the degree of certainty evidence must provide. The standard of proof is one of the decisive questions in the present case. There is general agreement on the standard of proof. The court must be fully convinced that it has been clearly established that the crime of genocide or the other acts enumerated in Article 3 of the Genocide Convention have been committed. The fully convinced standard of proof applies to the proof of the facts, including genocidal intent, and the of conduct. The Gambia agrees that this is a relatively high standard. Of proof. The court itself speaks of a heightened standard of proof reserved for charges of exceptional gravity, such as allegations of genocide. In any case, the fully convinced standard of proof requires proof at a high level of certainty. While the parties agree on the applicable standard of proof, they fundamentally disagree on what that standard means in practice. Myanmar has submitted that although different wording is used, the fully convinced standard of proof is comparable to the beyond reasonable doubt standard, in the sense that they are similar in relevant ways. While the court may not have formally adopted the beyond reasonable doubt standard or its wording, the court's fully convinced standard is informed by the beyond reasonable doubt standard. The Gambia, on the other hand, tries to avoid the beyond reasonable doubt standard of proof like the plague, because it knows that if that standard is applied, it will not be able to prove its case. It therefore argues that the two standards are different and that the beyond reasonable doubt standard is of no relevance in the present case. Let me address the Gambia's arguments one by one. First, it argues that the beyond reasonable doubt standard is an unattainably high bar for the proof of genocidal intent. As pointed out in the first round in another context, this standard has not prevented this court and international criminal courts and tribunals from findings that genocide has been committed. The bar is not the standard of proof, but the fact that there is no sufficient evidence to prove genocidal intent. Second, the Gambia argues that the beyond reasonable doubt standard is a common law and a criminal law standard, and that because the court is neither a common law nor a criminal court, it cannot apply that standard. At the same time, however, counsel for the Gambia intimates that the fully convinced standard is a civil law standard when it tries to explain its meaning by reference to a Swiss law standard. It has been rightly pointed out by Judge Greenwood in the Pulps Mill case that international courts and tribunals have avoided the distinction between criminal and civil standards of proof familiar to common law. While the beyond reasonable doubt standard might have its origin in the common law, it has not prevented this court and international criminal tribunals from adopting that standard. Third, the Gambia asserts that fully convinced means something other than beyond reasonable doubt. Now, Myanmar has asked in the first round, what does it mean? On Monday, counsel for the Gambia provided the answer. Fully convinced means fully convinced. A masterpiece of tautology, a literary stroke of genius. But to be fair, later on, counsel for the Gambia offers you a layman's definition of the fully convinced standard, saying, if you wake up in the morning and you are still worrying about whether the standard has been met, then it has not been met. But why would you worry if you did not have doubts whether the standard has been met? Probably not just any doubts, but reasonable doubts. But how is it then different from the beyond reasonable doubt standard? How can you be fully convinced if you have reasonable doubts? Let me come to the Gambia's fourth argument why you should not be guided by the beyond reasonable doubt standard. No standard is needed because whether the court is fully convinced, the Gambia tells you, is a matter for individual appreciation. Even if it is for each judge to form his or her own view on the evidence, that process must be guided by some standard. Otherwise, you would be following in the footsteps of a person who recently proclaimed not to need international law, not to need international standards, who is only guided by his own morality, his own mind. While every assessment of evidence is subjective, it is not arbitrary. Fifth, the Gambia has advanced the rather curious argument that in this court there will not be weeks, months, years of witness testimony, and that consequences must follow from that. What this in effect means is, if you do not have a proper evidentiary basis, just apply a lower standard of proof. This surely cannot be the case. Finally, the Gambia claims that the high standard of beyond reasonable doubt is not necessary because the court is dealing with state responsibility, not individual criminal responsibility. The Gambia essentially argues that this court does not need to apply the beyond reasonable doubt standard because, as it says, no one is going to jail because of your judgment. Counsel for the Gambia told you, I quote, "That necessarily means that the degree of scrutiny will not be the same, will not be as acute." The Gambia is wrong when it implies that in a case of state responsibility, a lower standard of proof applies, especially in a case concerning the crime of genocide. There is also a contradiction in the Gambia's position on the standard of proof. Only a few days earlier, we heard from another of the Gambia's counsel that the applicable standard of proof is, I quote, "a relatively high standard of proof, and we feel that this is appropriate where allegations of genocide or other grievous international crimes are concerned." End of quote. A finding of genocide, both at the individual and at the state level, always has grave consequences. While no one is going to jail because of the court's judgment, a finding of genocide by this court puts the stigma of being a genocidaire on the state and its people for centuries. A whole nation would be regarded, like the Germans, as a nation of perpetrators. To affix on any person, natural or legal, a stigma of crime therefore requires a higher standard of certainty. This is even more true in the case of states whose vital interests directly concern the welfare of millions of people, who all, each one of them, will be adversely affected by a decision based upon a misconception of facts. Thus, instead of calling the beyond reasonable doubt standard of proof into question, the Gambia's arguments underscore its importance in the present case. Both on principle and on the basis of the court's jurisprudence, allegations of genocide must be proven to a heightened standard of proof, irrespective of whether this standard is referred to as the fully convinced or the beyond reasonable doubt standard. Mr. President, the distinction between individual criminal responsibility and state responsibility for genocide, which I have just addressed, also gives rise to Judge Hamoud's question to the parties. The Gambia tried to intermingle the judge's question with its argument concerning in order to create the false impression that Judge Hamoud shared the Gambia's view that the beyond reasonable doubt standard should not be applied in the present case. Your Excellency, you asked in the first part of your question whether the difference between the two regimes of responsibility for genocide should be considered when assessing the circumstantial evidence that establishes the genocidal intent as the only reasonable inference. The short answer, Your Excellency, is no. While there are differences between individual criminal responsibility and state responsibility, these differences do not concern the applicable standards of proof when assessing circumstantial evidence in order to prove genocidal intent. It is exactly because of the gravity of the allegation and the grave consequences that follow from a finding of genocide, both for individuals and for states, that the same high standard of proof applies. Before any inference can be drawn from circumstantial evidence, such evidence must have been established conclusively, or, as Myanmar submits, beyond reasonable doubt. Otherwise, if the factual basis for an inference is tenuous itself. The difference between individual criminal responsibility and state responsibility did not prevent this court from applying the same standard for inference that is applied by international criminal tribunals and courts. Thus, in the Croatia case, the court expressly confirmed that when inferring the existence of genocidal intent from a pattern of conduct, it followed in substance the same approach as the International Criminal Tribunal for the former Yugoslavia in the Ptolemy case. Let me turn to the second part of Your Excellency's question. Assuming that other motives or objectives of a state, in addition to its genocidal intent, can be established by circumstantial evidence, you ask whether this would negate the possibility of proof of dolus specialis as the only reasonable inference. The short answer, Your Excellency, is yes. However, there seems to be a misunderstanding. Other motives or objectives of a state, or better intents, like the intent to destroy, need not be positively established by circumstantial evidence. That is, they must not be proven by circumstantial evidence. Inference is a technique of drawing conclusions from circumstantial evidence by deductive reasoning. If there is only one other reasonable alternative inference, then the inference